And you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, it will.
Okay, go ahead.
On January 21st, 2025, at 12:32 p.m., Officer Aguilar was dispatched to 19380 Allen Road, that's Drink Saloon in Brownstown, regarding a larceny of a wallet. Upon Officer Aguilar's arrival, he spoke with our victim in this case, Miss Kaylee Wilhelm, who works at Drink Saloon as a waitress. Ms. Wilhelm stated that on Saturday, January 19th, while at work, her wallet went missing. Ms. Wilhelm was unable to locate her wallet at home, so she informed the manager on the January 21st. Victim Wilhelm explained that she and most waitresses placed their wallet and purse and personal property on the far west end of the counter inside of the restaurant. Ms. Wilhelm was able to review surveillance cameras and found footage of a female and a male that can be seen near that part of the counter. The unknown female at that time and male can be seen grabbing the wallet and passing it over to the male, who then stuck the wallet down the front of his pants. That day, the male paid his bill with a credit card and the receipt. It was shown to belong to the name Jordan McKinney. Ms. Wilhelm stated that she looked up the name on Facebook for that account and located the male's account on Facebook. Using this information, Officer Aguilar was able to confirm the male's identity with the use of lean SOS as Jordan Durain McKinney. Officer Aguilar made contact with Mr. McKinney on the telephone. McKinney stated he was at Drink Saloon on the January 19th with a female he had just met there. Officer Aguilar told McKinney about the situation and asked him if he knew anything about the stolen wallet, which he denied at that time. Officer Aguilar explained to him that there was video footage of him receiving the wallet from the female he was with and then sticking the wallet down his pants. McKinney then stated that the female asked him to hold the wallet. He did not know that it was stolen. McKinney then told Officer Aguilar he believed the female's first name was Octavia. McKinney later told Officer Aguilar it was his coworker and that he had a phone number for the female. McKinney stated he gave the wallet back to Octavia once they exited the establishment. Officer Aguilar then made contact with the female, Octavia Abercrombie. Miss Abercrombie stated that she was at Drink Saloon with McKinney, but did not steal the wallet to Officer Aguilar. Video surveillance from Drink Saloon was gathered during his investigation. Our defendant, Miss Abercrombie, can be seen reaching over the counter, grabbing the wallet, then hands the wallet off to McKinney. McKinney grabs the wallet, puts it down in front of his pants. On
Signs all over the doors.
January 29th, Detective Attard contacted our victim in the case via telephone. Victim advised that her wallet was recovered in a garbage can in the female bathroom on January 23rd, and everything that was stolen was in the wallet. Only the money was missing from her wallet. Victim believed she had somewhere between $300 and $400 inside of her wallet at the time it was stolen. On 1/29/25 at 11:49 a.m., Detective Attard contacted defendant Abercrombie via telephone. Defendant Abercrombie immediately confessed without being questioned to stealing the wallet from the bar and taking the cash out of the wallet and throwing it into the garbage in the women's bathroom. Defendant Abercrombie stated that there was only $170 in the wallet and explained that she had spent the money over the last several days on groceries and rides to work. Detective Attard asked about McKinney's involvement in this incident. Defendant stated that he did not know the wallet was stolen and did not receive or take any of the money in the wallet. On January 29th at 12:04 p.m. hours, Officer Attard contacted Mr. McKinney via telephone. McKinney stated he did not know the wallet was stolen and later gave it to defendant Abercrombie because he felt that it was unusual to just be told to hold the wallet. McKinney later found out defendant Abercrombie had stolen the wallet. McKinney stated he was not aware initially. What happened is stated he was not assisting Abercrombie in committing this crime. Items stolen during this incident was a black purse value of $150, $400 cash, unknown denominations, a drink saloon gift card, $42, Michigan driver's license, 2 debit cards, and 1 credit card.
Based on your testimony, I find the crime of larceny in the building as well as the crime of larceny. Less than 200 was committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint. I'll note you signed the complaint and dated it yesterday. You sent it over, and then I'm just changing the date to today's date. Have a great day. Sorry about delaying getting out here. My apologies. Thanks.
Take care. Thank you.
All right. Diamond Mercedes Gee, file 22B141007. I want everybody to know that, please, if you got a phone in here, it's got to be muted or else someone asks you to leave, okay? Please. Too much going on with that. Your name?
My name is Felicia Morris. Diamond G is my daughter.
Yeah, I got the note. I'm going to go ahead and adjourn it. She's going to have to bring proof.
Yeah.
She's going to have to bring proof.
Okay.
So I will, I need another page of a register, second page. We're going to give you a new date. Lisa, I'll just let you figure out the date down the hall there, whether it's, I'd like to do it next week anyway, okay?
Okay, we'll do the 14th.
All right, so we'll give you a copy of the notice. Good luck with all of that, okay?
Thank you.
Thank you.
Have a good day.
Good luck. You too. I'm just going to write on this register and leave it to you, okay, Lisa,
Okay, I'll take care of it.
take this thing, don't adjourn. C letter. All right, so that's what I'll do.
What day? I didn't.
It's August 14th, you said, right?
Yes, at 8:30.
At 8:30. Okay, all right. All right, so people against WADA, Caitlin Brianna WADA, 25T645-767. Morning.
Good morning. How are you?
I'm doing all right. How about yourself?
I'm pretty good.
I don't usually see people coming to court so bubbly. It's good to see. But you got to slow down though, okay?
I know.
You're going to slow down, right?
Yes, I promise.
Okay, because if you don't, next time you come here, I can't give you impeding, okay?
I know.
So that charge of impeding traffic, responsible or not responsible?
Irresponsible.
Irresponsible? Is that what you said?
Responsible?
Responsible?
Yes.
Okay, I'm
sorry.
just kidding.
Okay.
All right, 170 is your total. I'll dismiss the traffic signal. You can go down the hall and take care of that. Good luck.
Thank you so much. Have a good day.
You too. Thanks. Brock, Marquetta Denise Brock, 25T645906. Good morning.
Good morning.
Your name?
Mark,
All right, so you're going to plead to impeding traffic, right? Responsible or not responsible to that? I'm sorry?
Responsible.
I'll accept the plea. Speeding's dismissed, 150. You're all set. Cash, you're into the hall. Best of luck. Maurice Sivan Simpkins, 25W839179. But I have Kim Gilsbatch, Seated up at the table, my right, your left, please. Your name, sir?
Maurice Amasa, yes, sir.
Good morning to you. You're going to plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible to that? Plea is accepted. Let me just double check something. Yeah, 150 is your total. Cash you rented the home.
Okay, got it. 2 weeks, I just paid my son.
Sure.
$2,200.
No problem. August 19th, you can pay by.
Yes, sir.
If you don't have the money somehow, call the court, go on Zoom. I'll give you an extension. Just don't ignore me. Honor before the due date, okay?
Yes, sir.
Best of luck.
All right, shoot, go down there.
You don't have to go anywhere. You can leave the building. Just August 19th, you have to pay by.
Thank you.
Good luck. Kim Marie Gilsbach, 25W839-148. Your name, ma'am? All right, so you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Please accepted, 155, cash your end of the hall to your right, and you're all set. Original charge dismissed. Elise Ann Cosby, 24B147119. Could I have Luke Williams seated at the table over here? You can come up to the podium, Ms. Cosby, state your name.
Elisa Ann Cosby.
All right, you're charged with failure to refrain from having contact, direct or indirect, with Justin Cole and his immediate family. That is the charge. Plead guilty. If you're found guilty, this is a non-technical violation, a violation of the no contact provision. Your probation could be revoked and you could be incarcerated for a period of 90 days with your 771 status revoked and the conviction entered. Do you understand that?
Yes,
Did you sign the advice of rights?
yes,
Did you read it?
yes,
Did you understand it?
yes,
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
yes,
You have the right to a lawyer. If you cannot afford one, either way, I'll appoint you one at public expense. Do you understand me?
yes.
Would you like a lawyer?
I have one,
Who is it?
Steve, Max Dubin and Steve, but he's gonna be here today because, his newborn baby's in intensive care.
Jeez, that's too bad. Why didn't you just call and get an adjournment? I would have given you adjournment. You drove all the way from Johannesburg?
No, I've been down here.
You hired Mr. Dubin to represent you on this?
Well, I spoke with him yesterday. I spoke with him a few days ago, and yes, we were supposed to meet to retain.
I didn't ask you that. Did you pay him retainer money?
Not yet, because of his emergency situation with his baby.
All right. I'm gonna enter a not guilty plea for you. You'll hire Mr. Dubin. I'll make a note, right? That's what you're going to do?
Yes,
I'll give you a new court date and I'll give you a personal bond. You have to comply with all terms and conditions of probation, okay?
yes,
All right, personal bond, $500. Comply with all terms and conditions of probation. We'll give you a new date, which will be on
August 14th at 9:30.
August the 14th at 9:30, okay? So I'm entering a not guilty plea for you. I want to be clear about that. You go down the hall, get your notice, and we'll see you here then. Any questions?
no, thank you.
All right, good luck. Kenneth Jerome Luke Williams Jr., 25F243686. Your name?
Kenneth Jerome Quinn.
You're charged with failure to pay $305. If you plead guilty, if you're found guilty, you could be incarcerated, $309 actually. You could be incarcerated 1 day for every $10 owed. You could receive 31 days in jail. You can satisfy that in full by payment, in full by serving a jail term, or in part by payment, and in part by serving a jail term. You get $10 credit per day served. So if you paid $209, you'd owe $100. You'd only have to serve 10 days. You understand that?
Yeah.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that?
Yes.
You have the right to a lawyer. If you Cannot afford one, you can apply for one at public expense. Actually, I'll just give you one. Do you want a lawyer?
Yeah.
Where do you work?
Home City Ice.
I'm sorry?
Home City Ice.
Where is that and what is that?
Pinehurst, New Jersey. Deliver ice.
Okay, how much do you make?
So we 24 hours.
Why didn't you pay this?
Because like, when I got pulled over, I have a, I was doing DoorDash at that point. So I had a amount on my phone and the officer, it was raining that
You
day.
didn't show up. You didn't do anything. You lost. If you're gonna try to contest the ticket, you have to post a bond.
Oh,
You don't just not pay a ticket or not show up because you disagree. Is that what you're telling me? You disagree with what he wrote?
No, I called today. They told me that my court date was today.
The ticket was issued in April. You had
Yeah,
10 days to answer. Hang on. You had 10 days to answer. This is August. That's 4 months ago. You needed to call and request a hearing or pay the ticket within 10 days. You did neither. You went into default. So if you're saying you didn't pay the ticket because you didn't agree with the citation, that ship has sailed. You understand what I'm saying to you?
Oh, yeah. Oh, I didn't know that, sorry, but I didn't know. I wasn't aware. The address that they had, I moved from, so they told me they sent me to work. They told me.
You got the ticket, right?
Yes, I had a ticket. I called and I set up a court date. And then,
You
they
set
told
up
me
a
that-
court. Did he set up a court date, Lisa?
Yes, I called.
Slow down. Slow down. I'm gonna see where he set up a court date.
Let me
Nope.
check, Judge.
They would have come in front of me. Did you leave a forwarding address?
Yeah, so the address. that I
Hang on,
found-
slow down. I'm just asking, did you leave a forwarding address?
No,
Do you live in, whatever 2377 is in Hamtramck?
yes, that's where I live now. And
We sent you this back in June.
Judge, it looks like a default card came back in return mail with a forwarding address.
I'll give you a choice. I'll give you a choice. Go down and post a bond if you want equivalent to the amount here. That's the rule. And you can make a motion to set aside default judgment, or I'll set you up on a payment plan. Whatever you want.
I do a payment plan, I pay whatever today.
You can pay whatever.
Yeah, I'm saying that I can pay a certain amount down.
How much do you have today?
I feel like a couple hundred.
So you want to just take care of it that way?
Yeah. But I still get points on my, like I said, I got my money.
I can't do anything about the conviction at this point. Okay? But I will do this. If that's the route you want to go, I'll just have you pay $200 and I'll call it a day. I'll waive the balance. You want to do that?
Yes.
You understand the conviction's going to remain on your record, though. Balance waived, $200. Go down the hall, take care of that, and we'll call it a day, okay?
All right, thank you.
Good luck. White, David White. David Michael White, 25W839022. Good morning.
Good morning.
Your name?
David White.
You look like a lawyer. Are you a lawyer?
No, I got an interview that business.
All right, well, good luck with that.
I appreciate that.
All right, so what are we doing? You're pleading to impeding traffic, right?
Yes.
What happened here? Wait a minute. No, you didn't show.
It was originally scheduled for July 8th and.
Let me see something. Give me 1 minute here. Oh, I said motion to set aside default judge. I see. Did you meet with the department rep today?
I did before I came in here, yes.
Let me see something. You met with the department rep? I don't know why you didn't send anything in here. Who'd you meet with? Well, I don't have anything in here. So, did I miss something? Good morning. How are you?
Good morning.
Can you do me a favor and take this to Lieutenant Toller for me, please?
Of course.
I don't see any stip form in here on this case.
I can do that for you.
Thank you very much. Have a seat right at the table there. Cassidy Angeline Reardon, 25F244405. Oh, I'm sorry, officer.
Yes, sir.
That needs to go in that file. My apologies. Ma'am, your name?
Cassidy.
All right, so you met with the department rep. You're going to plead to impeding traffic, right?
Yes,
Responsible or not responsible to that charge?
responsible.
All right, I'll accept the plea, 150, you're all set, okay? Original charge dismissed.
Thank you.
You all right?
Yeah.
You look scared. Good luck.
Thank you.
Martin, Ray Christopher Martin, 25F244339. Your name, sir?
Raymond.
All right, so you met with the department rep and you're going to plead responsible, excuse me, to impeding traffic, true?
Sure.
To that charge, responsible or not responsible?
Responsible.
All right, you got insurance?
Yes, sir.
Okay, you got 3 of those on your record. You aware of that?
I was going through a rough spot financially, but I've been insured for about 2 years.
All right, I'll accept the plea, dismiss the original charge 155, okay?
Thank you.
Good luck. Crystal Martin? Crystal, I just didn't see a slip form in there.
That's okay. It just got turned around backwards.
Oh,
Sorry about that, Your Honor.
That's all right. Crystal Nicole Martin, 25F243723. Your name, ma'am?
Crystal Martin.
You're charged with a failure to pay. This is a show cause. Excuse me, for failure to pay $213. If I find you didn't pay and your failure to pay was not without your fault, you could be held in contempt and jailed 1 day for every $10 owed. You get 22 days. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing. Do you understand that?
Yes.
All right. You want water? You have all the money?
Yes.
Why'd you wait so long?
Just busy. I work in the nights.
What's that?
I work in the nights, just busy.
Busy.
Yeah.
You gotta take care of your tickets, okay? You cost yourself more money.
Definitely.
I'll cut it down to 185, balance weight, okay? Down the hall and take care of that. Good luck.
Thank you.
Next time, call the court, deal with it, okay?
Thank you, yeah.
O'Neill, Tyler Aiden O'Neill, 25W839210. Your name?
Tyler O'Neill.
Gotta be careful, you caused an accident, right?
Yes, sir.
To the charge impeding traffic, responsible or not responsible?
Responsible.
Please accept the original charge dismissed 195. Cashier under the hall to your right. Good luck. People against David White, 25W839-022. Your name?
David White.
You're gonna plead to impeding. I have it now, okay? I don't know how I missed it, but at any rate, to the charge impeding traffic, responsible or not responsible?
Responsible.
How much of a bond did you post?
And the line fee.
How much bond did he post, Lisa? Can you tell me?
I believe it was 165, but let me look real quick.
Okay.
Yeah, 165.
All right, so I'll accept the plea. I'll set aside the default judgment. Fines and costs are 165. Just go down the hall and take care of that, okay? I don't know whose name it is. I don't see a bond receipt, so.
Doug.
Pardon?
He actually paid it instead of posting as a bond, so he's all set.
I see. So you're all set. You can leave.
Thank you.
Good luck.
Thank you.
Caitlin Marie Poor, 25W839-149.
Good morning.
Good morning. Your name?
Caitlin Ford.
I can't take this. You got 4 moving violations, it looks like, in the last 5 years. So you can either plead to 30 and a 25, which is a 1-pointer, or you can set it for an informal hearing, whatever you want to do.
I'll take the point.
To the charge 30 and a 25, responsible or not responsible?
Responsible.
All right, I'm going to accept your plea. 135 is your total, okay?
Thank you.
Good luck. All right, Daniel Condon, Daniel Edward Condon, 25W83851. Your name?
Daniel Condon.
Why'd you wait so long to come and talk to me?
What do you mean, sir?
Your ticket was issued in April.
No, I know, I set up a payment plan, Your Honor, and I just forgot about it. I received another ticket, and I paid it.
How much do you have today?
Sorry?
How much do you have today?
I can't pay anything today, Your Honor.
Where do you work at?
I need to request more time.
Where do you work at?
I work at Manheim Auto Auction. I was working through a time service making 19. They made me hire in for $5 less, so I'm making $5 less an hour.
When can you pay this?
If you could give me as much time as possible,
Do you get paid weekly or bi-weekly?
weekly. But the next 2 weeks, I have to pay my insurance and my car payment.
You pay $35 per week, beginning August 25th. Can you do that?
I'll make it happen.
If you don't have the money somehow, you call the court or come in here on or before the due date. Call the court, we'll go on Zoom, or you come in here on or before the due date. I'll be glad to work with you, okay?
You said August 25th?
Correct, that's a Monday.
Okay.
That's 2.5, almost 3 weeks, all
All
right?
right, thank you.
Good luck. Amy Nicole Zugaj. Two four T 702-732. Is there a Emily Pardo here? Is anybody here that resides on Maidstone in Trenton on this case? Okay, your name?
In Nichols Gate.
It's, okay. Okay. Nobody's objected. So I'll just indicate, you staying out of trouble?
Yes, sir. I've learned my lesson.
Good. There being no objection and you having been compliant, defendant granted early discharge from probation. You are all set.
Thank you so much.
Okay, we're gonna send you that paperwork and you should have it the next few days, okay?
Thank you so much. I appreciate it.
Best of luck. Thanks. All right. Dean Allen Langle. 25T645958. Your name, sir?
Being my Joe.
Good morning to you. You're going to plead to impeding traffic, right?
Correct.
Responsible or not responsible to that?
Responsible.
Please accepted. 160 is your total. Cash your end of the hall. You're all set. Best of luck. Brad Allen Newick. How you doing?
Okay.
25T645787. Good morning. Your name?
Brad, good night.
Okay, you're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
Please accepted. 195. You're all set. Original charge dismissed. Good luck. Cash your end of the hall to your right. Thanks. Barbito. Christopher Joseph Barbito, 25T646004. How you doing there?
How are you?
Your name?
Christopher Barbito.
All right. Got a coat on and everything, huh, Mr. Barbito?
Yes, sir.
Good for you. You're going to plead to, this is a commercial vehicle charge, huh? Why are you driving so fast?
There's really no reason for it, honestly.
All right, you're going to plead to impeding?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, 185, cash your end of the hall to your right. Be careful, please. Slow down, all right?
I will.
Good luck. 2, Beisel. Joshua Daniel Beisel, 5B148957. Mr. Beisel, your name?
Joshua myself.
Okay, you're gonna plead to distracted driving, true?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Please accept it, 155, you're all set.
Thank you, sir.
Have a good day.
You too.
Kiera Nicole Duchesne. 25B148718. How you doing?
Good.
You all right?
Yeah.
Your name?
Here.
Okay. You're gonna plead to impeding, right?
Yes.
To that, you gotta be careful, okay? Caused an accident, right? Yes? You caused an accident?
Kind of.
Well, tell me.
Um,
Listen, don't be shy. Nothing's gonna happen. Go ahead, tell me what happened.
it was a,
Gotta keep your voice up, though.
it was a red light, and then I like looked both ways, it was clear, and then I went, and then like I pulled out into like the second,
Keep your voice up. I can hardly hear you.
oh, sorry.
So you were turning on a red, right? Or not?
Yeah, yeah.
And so somebody else had the right of way, right?
What?
The other car had the right of way, right? When you turn on a red, they have the right of way, right?
Yeah.
And you pulled out in front of them, is that what caused the accident?
Like, they like ran a red light, and then.
They ran a red light?
I think so, well, I don't know, but I like turned, I'm sorry, like, I'm really nervous.
All right, listen, don't be nervous. Let's just do this. I'll just take the plea. We'll get you out of here, okay? All right, to the charge of impeding traffic, responsible or not responsible? Responsible? I didn't mean to upset you. There's nothing to be upset about. Everybody makes mistakes. Nobody was hurt, right? Right? You got the car fixed, right?
Yeah,
Okay. All right. Do you plead responsible to this impeding? Yes? You have to answer out loud. All right. I'm sorry. I did not mean to upset you. Okay? All right. What grade are you in? Or are you done with high school?
11.
Okay. All right. I understand. You're a new driver, right? Okay. 195. You're all set. Relax. Take a deep breath. This is not the worst thing that's going to happen to you. Good luck. Brandt. Reese Timothy Allen Brandt. 25B148698. How you doing, Mr. Brandt?
Good, you?
Not too bad. You're gonna plead as charged, is that right?
Yes, sir.
To that charge, responsible or not, or not responsible?
Responsible.
You gotta be careful, okay?
Yes, sir.
Caused a 3-car accident, looks like here.
Yes, sir.
195. You go down the hall and take care of that. Good luck. Thanks. People against Van Tress, Felicia and Van Tress. 25B 146084. How you doing?
Good, how are you?
Your name?
Felicia and Angela.
All right, so you're gonna plead to impeding, right? Responsible or not responsible to that?
Responsible.
Okay, I'm going to accept your plea. 170 is your total, okay?
Thank you.
Best of luck.
Have a good day.
You too, thank you. All right. Can I have Alexis Sophia Peterson? 25B 148716. Good morning. How you doing? Your name?
Alexis Peterson.
All right, so you are going to plead responsible to impeding, right?
Yes.
To that charge, responsible or not responsible?
Responsible.
Gotta be careful, okay? 195, original charge dismissed. Good luck.
Thank you.
You're welcome. Brian Bush. Brian Keith Bush, 25T6459708 and B. Your name, good morning, your name?
Brian Bush.
You're gonna plead to impeding traffic and no proof of insurance, true?
Yes, sir.
To that charge of impeding, responsible or not responsible?
Responsible.
To no proof of insurance, responsible or not responsible?
Responsible.
Do you have insurance
Yes.
now? Let me see it. Please accept it to impeding, that's 195. The no proof of insurance, that's in effect now, right?
Yes. I had the one that was in effect at the time, and then we refinanced our house, and we got a good deal on a bundle, so I just bought different insurance yesterday as well, so I have both.
You didn't have car insurance though on this offense date, right?
Not on me, no.
Okay. But you had it in
Yes.
effect? You have proof there that you had insurance on that date, which is July 12th?
Yes, sir.
Let me see it. John, can you just check that, make sure? So July 12th, and that was a, what kind of car?
Chevy Traverse.
Yeah, he was good through October 25.
All right, I'm gonna make it $50 on the insurance, okay? 195 on the impeding. Okay?
Is it okay if I have a little bit of time?
How much do you have today?
I can do 50 today.
You pay that now, the no insurance. How much time do you need to pay on
I
the
could have the whole thing by next Friday.
August the 15th, okay?
Yes, sir.
If you need more time, call the court, we'll go on Zoom, I'll give you an extension, or you can come in here on or before that date, I'll give you an extension. 8:30 in the morning, okay?
Yes, sir. Thank you.
Good luck. Gavin Lee Darnell, 25F244395. Could I also have Brian Wada seated up here, my right, your left? Your name, sir? You're going to plead to impeding traffic, true?
Yes, sir.
Responsible or not responsible to that? Okay. $160 is your total. Cash your end of the hall to your right.
Thank you.
Good luck.
Thank you.
People against Brian Patrick Wada, 25F244498. Good morning, your name?
Good morning, Brian Wada.
You're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, 165 is your total. Cash your end of the hall to your right. You're all set. Good luck.
Thank you.
Mohammed Naeem Khan,
Yes, sir.
25F244284. Your name, sir?
Mohammed Amin Khan.
You're gonna plead to impeding? Responsible or not responsible to? All right, you're getting up there with these though. You gotta slow down. If you see my name on the next case, don't come in and ask for impeding. I won't give it to you, okay? 185.
Thank you, sir.
Good luck. Horn, Nicholas J. Horn, 25T704225FY. Your name? You're charged with failure to refrain from consuming alcohol, testing positive on a chemical, ETG, on a sober link rather, on July 18. That's count one. You understand the charge?
I do, Your Honor.
Count two, you failed to refrain from consuming alcohol, testing positive July 18 at 7:33 in the morning. You understand that charge?
Yes, Your Honor.
Count three, failed to refrain from consuming alcohol, testing positive July 18th at 7:49. You understand the charge?
Yes, Your Honor.
Those are three counts, but they still arise out of the same event, transaction, or occurrence. So I'm going to go ahead and just count it as one. So in other words, the most you could get is 5 days if you plead guilty to these. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
I did.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial of any kind. You understand that?
I do, Your Honor.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Yes, Your Honor.
I'll enter a not guilty plea for you. We're going to get you a lawyer. You're going to come back in front of me here today. The only problem is you do have 3 prior technical violations. So on a 4th, your probation could be revoked and you could be incarcerated for the maximum provided by law, which in this case is 1 year on the attempt R&O and 90 days on the disorderly. Do you understand that?
Yes, Your Honor.
You have any questions?
No, thank you.
I'm going to enter a not guilty plea. I'm going to give you a lawyer. You're going to come back in front of me with that lawyer. And then we'll have your hearing. Okay?
Yes, Your Honor.
All right, we'll see you back here in a few minutes. Thank you.
See in the hallway.
And these are, again, the same charges. I just want to be clear. You have 2 counts. So both counts 1 and 2, you have these violations. And I'll see you back here. Thank you. Here you go. All right, Jody Lynn Kaminsky. 2. 5W832. Ms. Kaminsky, how are you?
I'm okay, I guess.
Your name?
Jody Lincoln.
How'd you convince him to dismiss this?
I just told him the truth. I didn't know that you weren't supposed to record back on the highway. I really didn't.
Okay. Well, hey, maybe you should have gone to law school. You still could. Case dismissed, motion of the plaintiff.
Thank you.
Good luck, thanks.
Thank you.
People against Shafiq, Muhammad F. Shafiq, 25T645843. Good morning, sir. Your name?
Mohammed Shafiq.
You're going to plead impeding, right?
Yes,
Responsible or not responsible to that?
responsible.
I'll accept the plea, dismiss the speed, 160. Cash your in all to your right. Good luck.
Thank you.
Tariq Zarani, 25F244313. How you doing?
Good, how are you, Your Honor?
Not too bad. Your name?
Tariq Zarani.
All right. You're going to plead impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
Please accepted, 150. Cash.
There is something I want to address, Judge. I didn't realize until I pulled into the parking lot today that I left my backpack that's got my wallet and my lunch. Is it possible to do it like tomorrow morning, first hour?
Yeah, you just admitted to not having a license on your person.
I don't know, I do have.
You're fine, you're fine, you're fine.
license that I
You're
can
fine,
drive.
you're fine. No problem. I'll give you till the 7th. How's that?
Yeah.
150 is your total.
Sure. Thank
Okay.
you, Your Honor. Can it be paid early?
No,
The 7th,
we're gonna
right?
throw you away if you do. Yeah, of course I can.
7th,
You can pay today, you can pay tomorrow, you can pay Thursday.
okay. But like, what is the due date?
Thursday,
Thursday, okay.
the 7th.
Thank you, Judge.
Okay?
Thank you, I appreciate it. Thank you.
Have a good day. Good luck.
Sir, thank you.
Lindsay. People against Stephen Bruce Lindsay, 25F244281. Mr. Lindsay, how you doing today?
Good, how are you?
Your name?
Stephen Larceny.
All right, so you're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accept the original charges dismissed, 150. Cashier end of the hall to your right. You're all set. Good luck.
Thank you, sir.
You're welcome. Amaya Danielle Saad, 25F244280. We getting backed up down there, Lisa?
No, she's doing good.
What's that?
No, she's doing good.
Okay. Your name?
Maya Swan.
You're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accept the original charge dismissed, 165. Good luck. Can't wait to get out of here, can you? Have a good day. All right, Faizan Chowdhury. Faizan Zulfikar Chowdhury. 25B148998. Okay. Okay, so you're gonna have a hearing on this?
I guess so. I didn't know that was gonna happen.
You parked it next to a fire hydrant, it says.
I've been parking there for 25 years.
It doesn't matter, was
No,
the,
it wasn't. I know my distance. I had a mark.
that's no problem. You wanna have a hearing, I'll just, hang on.
Okay.
I can't hear the case without him being here, so I'll set it for an informal if that's what you want me to do. That's what you
Yeah.
want me to do?
That's what it is. It's
Okay.
inefficient. It's just a principle thing. at this
That's
point,
all right.
You know?
That's okay. That's what,
Unfortunately, we're being harassed in that subdivision.
that's why we're here. You can have the hearing, no problem.
I knew if that was the first step I needed to do, I would have done that. Didn't have that option. I had come in with another, so it's like taking more time off of work or something. And I talked to this officer, I know you can't hear it, but I understand. But this is very frustrating.
It says you parked in the fire lane next to
I'm
the
not in
fire.
fire lane. And fire lane's on the other side when I'm.
Okay, I'm not
I have
arguing.
pictures.
I'm not
I
arguing.
understand you can't listen to it, but I'm not in the fire lane.
I'm not arguing with you. I don't have a problem. We'll set,
I talked to the officer when he came back later and he.
Lisa, give me a date on this, okay?
August 14th at 9:30.
You're gonna come back next week, August 14th at 9:30, okay?
Can I get another date? I have an appointment at that date, August 14th.
What time's your appointment?
It's in the morning. I have a closing in the house.
What time's your closing?
It starts at 8 AM. I'm not gonna be back here in this area by 9:30.
What time can you be back here?
Sure. Probably by the afternoon. I'm going all the way to Farmington. And it's gonna take me a few hours.
Okay? Can we do the 15th, Lisa?
It's a Friday.
Let's do can we do the 13th?
Yes.
August 13th at 9:30. So we'll
The
notify,
doctor's appointment for the children.
what's that?
I take the kids to go to the doctor's.
What time?
13th.
What
It's
time?
at 9:30.
Where's it at?
Dearborn. I can be back by 11 from that.
You want,
She's getting a bracelet off, so.
Lisa, can we do the 12th?
It's your civil day.
That's okay. We'll do August the 12th at 9:30, but send that over to Brownstown by email or whatever, August the 12th at 9:30, okay? So we'll see you in a week. You can go right down the hall, sir, go right down the hall and they'll give you a paper notice, okay?
Okay.
Awais Chowdhury Akram, 25B148974. Your name?
Always Akram.
You're gonna plead as charged to 5 over, right?
Yes.
That charge, responsible or not responsible?
Responsible.
Please accept it, 135, cashier into the hall. Good luck.
Thanks so much.
Forrest Michael Perez, 25B148508.
Where are you?
Good morning, your name?
Forrest Perez.
Okay, you're going to have a hearing on this, right?
Please.
You want to do the 14th on this one, Lisa, or
Yes, 9:30.
So we'll do an informal hearing. That's what you want, right?
Yeah.
August the 14th at 9:30.
Fantastic.
Okay?
Thank you.
Good luck. Matthew James Cho Kazmarek, 25I414924. Your name? You're charged with failure to provide proof of completing 1 day of community service by June 20. You have no technical violations thus far. This is not even a probationary case, but I'll still adhere to that rule. You could get 5 days if you plead guilty, if you're found guilty. Do you understand that?
I do.
Did you sign an advice of rights?
Yes, I did.
Did you read it and understand it?
I did.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I do.
You have the right to a lawyer. I'll give you one at public expense if you want one. Would you like one?
Yes.
All right, I'm gonna enter a not guilty plea. Go talk to a lawyer. Come back in front of me. It might take a while, but you come back in front of me.
I've seen all of it.
He'll set you up with a lawyer out there. Holly Lynn Jacobs, 25F244424. And could I have Kyla Davis seated at the table, my right, your left over here, okay? Your name, ma'am?
Holly Jacobs.
All right, so you're gonna plead impeding, right?
Yeah.
Responsible or not responsible to that?
Responsible.
Please accept it, 150.
Thank you.
How you doing?
Sit down here.
Well, you're gonna come up here now. Kyla Madison Davis. 25F244425. How are you?
I'm good. How are you?
Good. Your name?
Kayla Davis.
You're gonna plead to impeding?
Yeah.
Responsible or not responsible to that? All right, I'm gonna accept your plea. What happened here? How old are you, 17, 18?
18.
Did you graduate? Next year.
No, I graduated.
Okay, good. What are you doing now?
I'm moving to Tennessee.
Really?
I'm gonna go to community college, become a stenographer.
To be a stenographer?
Stenography, like ultrasound.
Oh, I see. Well, great. Whereabouts in Tennessee?
It's like 20 minutes from Nashville.
Nice. Well, 165 is your total. I wish you well. I'll dismiss the original charge. Best of luck to you.
Thank you.
Have a good day.
You want a customer truck?
Yeah.
Okay. Zoom in right now.
Is
Yeah.
Gates ready? Or whoever?
Gave.
Who's the lawyer? Who?
The ATM?
Okay.
I'll bring in,
here on the tablet a plea bargain rejection that you've signed with Mr. Burbank that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that and go to trial. I just want to make sure you understand any possible consequences, what your options are.
Yes, ma'am.
Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, I'll get that done. And Mr. Rose, I want to make sure you understand, the lawyers already know, once your case is on the trial docket, I will not accept this plea agreement after today. If you change your mind later, you can plead to something different. The only way it would be much different would be if there was new evidence that either your attorney or the state's attorney did not have at this time, okay? All right, and have y'all, is there anything you're waiting on, is discovery-wise?
No, Your Honor, the state's ready for trial.
Okay.
We're ready, Judge. I'd ask maybe you could be specially set so I can clear my docket out.
We'll get it set in the next day or so and let y'all know that date. If there's any issues, just let me know about that date.
I appreciate it.
And if you need a protective order or anything like that, to be here, we'll make sure and take care of that and get it done as well. All right, thank you. You can go back with the bailiff. And then you've got Bryce Thomas, sentencing. Trying to remember which one. Yeah. See. All right, so you're Bryce Thomas, and Mr. Thomas was previously in court, entered pleas of guilty in cause number 24 DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24 DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24 DCCR 0391, pled guilty to the state jail felony offense of theft of a firearm. Cause number 24 DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State has
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
I reviewed them one evening.
State reviewed all 35 pages of yours.
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, sir.
All right, Mr. Burbank, you may proceed.
Your Honor, this is a very young kid that in a very short period of time stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was encased by his family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons are off the street and back into the department.
Could you speak up a little bit, please?
Oh, back into the department. We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that you can do. At the very end, state jail does the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, that you do place him on probation, so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if he can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
What do I have to say? I could just say it's just young, dumb, just being in jail at a young age and not really knowing. I got write-ups.
Yeah, but once you get several write-ups, the whole point of growing up is to learn from your mistakes.
Yes, ma'am. Yes.
So if you keep getting write-ups, then you can't just say I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb, but this is ridiculous. I know our jail cannot wait for you to get out. Cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, I made the state's position clear in our sentencing memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in this case, which I believe are
stealing out of cop cars.
Stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement, Your Honor. Long gone are the days where there's a low caliber Saturday night special that these kids use, in some type of a crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I'd ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for on some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think you can.
Because when would it start?
It will start after he finishes his period of incarceration.
Okay. So whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
Okay. I don't believe so either, Judge. But again, I'm happy to get you some case.
No, I appreciate the idea. Again, we've done it sometimes. What are you doing with all these?
In Texas, a judge
Not shooting people.
Sir?
Not shooting people.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns? That's all that's happening with these guns on the street is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do
I
you?
have before, but
Have you?
yes,
Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm gonna do, because I agree with Mr. Coleman. I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not gonna go make that type of bad decision again. But I'm not giving you probation on everything. You wanna change your life and do better and not be young and dumb, you're gonna have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody. And part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that?
Mm-hmm.
With a deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
Well,
A
I
fourth.
understand that, but a sexual kind of.
May I respond, Judge? That is a reduced plea to a reduced charge.
I agree.
might point that out.
Can I give a straight on indecency though? Hold on. I think it has to be deferred. Hold on. Yeah, it has to be deferred. Okay, so I'm going to go back in that cause number, which ends in 0392. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then, if you violate that probation, you could be sentenced up to 10 years in that case. So you're going to be under supervision or in custody for a very long time. So if you really want to change your ways, you're going to have every opportunity to do that. If you don't, you're going to end up, number one, you're probably not going to make parole if you keep acting like you've been acting here. If you get to prison and you act like this, you're not going to make your parole. You're going to do that whole 7 years. That's going to be up to you. The sooner you get out and act right, the sooner you can start this other probation and get off of it, grow up, and maybe change your life. That's going to be up to you. On that deferred, I am going to order a $500 fine that you follow all of the conditions of probation. That's going to include sex offender treatment, going to whatever classes are necessary, staying clean, not getting in any trouble, all of those kinds of things. Do you understand? Mr. Coleman?
Your Honor, is there a deadly weapon finding option with these weapons?
I don't think so.
You don't think so? Okay. Okay,
Unless you can, I don't think that's,
we didn't allege it.
well, and they're not, possession of a prohibited in the 3G, so I don't think we can,
Okay.
yeah.
I'm sorry.
All right, so all of these are actually wrong because y'all marked off plea bargain and there wasn't a plea bargain. So I'm going to hand you the trial court certification in all of your cases. This shows that these were not a plea agreement.
It was a plea agreement, Judge, because there's a, no.
Oh, because of-
No, there was an unauthorized use that we agreed would be dismissed.
And also the lesser offense in that, so there was consideration taken, so this was an agreement, at least for those reductions. Okay, so you have waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. You can go back with the bailiff.
I thought you.
Yeah.
We have Mr. Jenkins that you're gonna.
Yes, ma'am, thank you. All right, are you Camden Jackson?
Yes, ma'am.
And Mr. Jackson, you were previously in court, entered a plea of guilty to the second-degree felony offense of engaging in organized criminal activity. I've received the pre-sentence report as well as incident reports from the Jefferson County Jail. Has everyone had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Judge, I'm sure the court would like Mr. Jackson to take a little bit more responsibility for what he did in his version, and I would also assume that his next comments are gonna be the talking to that everybody else in the jail is doing for me.
Mr. Jackson, I've got 16 pages of jail incident reports. Each page holds 2 to 4. Do the math on that, and that's a lot of you being exceptionally disrespectful to the officers that are there. And so what I'm wondering is why you think, I mean, since you entered your plea in this case, you were caught with a shank, 2 different types of shanks, and you've been fighting? Huh? You can speak where I can understand you first. Speak up. What do you want to say?
I was talking to the guard, I was talking to the lieutenant. I was trying to talk to him to get that thrown out. They ain't find it on me.
No, they found it in your bed.
Oh, it wasn't.
Okay. What about the other 16 pages? What about telling the officers, I don't have to do shit? What about telling the officers, I don't give a F about none of that? What about that? Is that you? Over and over and over? If you don't give a shit, then why should we? Do you understand what I'm saying? You want to spend your life in prison? Because that's what you're asking for. It's no behavior for me to go, oh, let's just put him on probation. It'll be great. He's going to follow the rules. You can't even follow the rules when you're locked up. What makes me think you're going to follow them when you're out? I mean, the agreement that y'all have reached based on what I understand is very little criminal history, mostly because you're young and you haven't had time to do a whole lot. What is the status of the Hardin County cases? Do we know?
Yes, Your Honor, they're waiting for us to resolve these cases, and then they'll be next in line.
Okay.
When we come to court, after we leave, I always inform them what we're doing, so they're aware.
Okay.
Judge, that kind of goes to the notion of, obviously, we were going to request if the court is in agreement with the following plea, ISF, that he cannot do with those pending. So our understanding and our agreement was for ISF with the understanding that he would dispose of those cases very timely so that he can then go to ISF if that's what this court orders.
Yes, Your Honor.
Okay. So here's what I'm going to do, Mr. Jackson, and the rest is going to be up to you, okay? I'm going to follow the agreement that you made with the district attorney. I'm going to find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to defer all proceedings for a period of 7 years. You will be ordered to pay a $500 fine. You will be ordered to enter and successfully complete the cognitive track of the ISF program. That is a whole program, especially for you young people, to hopefully help you to make better decisions. But here's the thing about ISF. You're going to go to Hardin County from here, take care of those cases. And when you do get to ISF, one incident report is a violation of your probation. 0 tolerance. So you're going to have to prove to me while you're waiting in jail. In addition, while you're waiting in jail to go to Hardin County, if I find out you misbehave in Hardin County, any of those things are going to be violations of your probation. Do you understand? A condition of your probation is going to be that you follow the rules in our jail, in Hardin County Jail, and in ISF, whatever those rules are. It's not going to be cussing at and calling names to the correctional officers who are just there doing their job. It's not going to be fighting. It's not going to be hiding things in your whatever. You understand? Because you may never see the light of day. You're going to be right back in here on a motion to revoke your probation. And because this is a second-degree felony, if you are back in here, the range of punishment, if I find that you violated your probation, is minimum 2 up to 20 years in prison. You understand that? Okay. If you take advantage of this opportunity and change the way you're acting, and are you successful on this probation, this is your chance of a lifetime today, because you do not have a conviction on your record. You're not a convicted felon. And at the end of the probation period, if you're successful, the case gets dismissed. You'll never be a convicted felon. The other side, again, though, one hiccup. You're on 0 tolerance from the beginning on this. You're back in here with the motion to revoke and going to prison. Do you understand? A condition of your probation also, if it's not in here, is going to be that you are not allowed to be in the possession of or around any firearm. So if there are firearms in your house where you're living that aren't yours, they have to be locked up, or you are not allowed to have them. You're not allowed to have a firearm, period. Do you understand? Okay.
And Your Honor, just for the record, we do believe that he'll be able to make this probation and won't be back here. His family is here. They've always been here, so they're
Good.
ready to support him with whatever he needs to make sure that he makes it over the hump.
I hope so. I'm glad that they're here. And here's the thing. You probably don't like their rules either. Guessing from how you're acting, I don't think you like anybody telling you what to do. But at this point in your life, until you get off this probation, there's going to be a bunch of people telling you what to do. And you're just going to have to take that because you're the one who engaged in this behavior, right? So grow up, take responsibility, and change it. It's all up to you to do that, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. And thank you all for being here.
Thank you, Your Honor.
Thank you, sir. Ms. Holmes, you have is Ms. Holmes here? Kevin Harmon, that's a sentencing? Kevin Harmon. Bye. Good morning. All right. Finally. Look at this one. Get it, just a check mark.
I'm about fired up to argue this guy's report. He's only got like 2 pages.
No, I've got a good check mark on this one.
After 35.
I mean, seriously. All right, sir, you're Kevin Harmon. And Mr. Harmon was previously in court in cause number 24, DCCR 1612, entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Sean, we have.
Are there any additions or corrections?
None from the defendant, just that he takes responsibility for his actions.
Okay.
I didn't have anything to add, Your Honor.
All right, so Mr. Harmon, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because this felony conviction will not be on your record as a conviction. And at the end of the probation period, if you're successful, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would become a convicted felon, and I could sentence you anywhere in the range of punishment, which is between 2 years up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And you can go back with the bailiff. Probation will give you some information on what to do when you get out.
Thank you, Your Honor.
Thank you.
Judge, I reset one of Marvin Lewis's and I'm resetting Lori Brazos.
Okay.
Marvin Lewis at the Charles, starts with the B.
Braceland Charles?
Yes.
Okay.
Is reset.
Okay.
And Lori Brazos, Bob DeWitt.
Thank you. Mr. Radford?
Yes, ma'am.
You've got Michelle Cormier.
Yes, ma'am. She's on the other side.
There, she's next door. Okay, just let me know when she's here and I'll take it up as soon as she gets over here. What about Corey Flemings?
He's a plea bargain rejection. He's here.
Okay, let's take care of that one while they're getting her.
Mr. Martin is a plea to misdemeanor Thompson.
Okay, thank you.
I've got a discovery issue on Mrs. Cormier.
Okay.
Mr. Coleman, I have that Corey Flemings is 8, is that correct?
It's at 8 today, but I think he can become, he can be enhanced with a vigil.
I see one enhancement. Is there more that aren't in the?
There is an out-of-state judgment from Louisiana that is, that under the penal code would be a 30-degree felony.
No, I need to admonish him of that because I was not aware of the out-of-state prior.
Y'all want to visit for a minute?
Yeah.
Yeah, y'all take a look at that and that way, once we do it, it'll all be there. I'll hold it.
Yeah, we need.
Mr. Flemings needs to just
Visit.
go back for a minute.
Ms. Cormier's here, Judge, and Mr. Coleman.
Okay.
Yeah, just go back because I got to talk to you about that. I was not aware of that.
I'm trying to pull your motion up. I can bring my whole file.
Michelle Cormier?
It's a discovery motion.
Give me just a second. All right, ma'am, are you Michelle Cormier? Yes, ma'am. And in cause number 25, DCCR 0153, Ms. Cormier is charged with a first-degree felony offense of murder. And what is the announcement?
Judge, this event occurred in the Jefferson County Jail. I asked Mr. Coleman if there were any surveillance videos that were relevant to the incident, and he told me I needed to subpoena.
Actually, there was a two-part request on part of Mr. Robbery. He also asked for the criminal history of, was it the deceased?
Yeah, the deceased.
And I'll make that available.
Yeah.
Okay, the videos as well. I mean, if there's.
They're in the custody of the state.
Yeah, if there's evidence.
I was trying to pull up his request? Because I think it was more global than that, Judge. I think you asked for videos like to and from the jail, which
Any relevant surveillance videos is what I want.
Okay, all right. I think that's something that the state would need to get with the jail and find out if there is any and provide that in discovery. If it's inculpatory or exculpatory, I think would be considered discovery.
Forgive me for being unprepared on this.
No, that's
I'm trying
okay.
to pull up the actual motion because I think there was more of a.
Well, y'all visit, work out what you need, and if it's something that they won't release to you, then we can get a subpoena or an order done. If there's something that you feel like is overly broad, y'all talk about it, see if you can work it out. If not, we'll have a hearing on it. But I'll just reset it for a normal announcement to give y'all time to work on all that.
Okay.
Okay, you can go back with the bailiff.
I will go visit with Mr.
What about Traylon Martin?
He's a plea to a misdemeanor time, sir. If you want to do him now.
Let's get Traylon Martin.
Traylon Martin.
My mouse, my pointer's all jumpy for some reason.
Corey Fleming's and a Jacorian.
Oh, really?
Where'd you go?
Oh, any idea why this would be all jumping around? I can't. Maybe in a second. All right, you're Traylon Martin?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, ma'am.
Judge, with the court's permission, based on the facts of this case, and some of the circumstances, we have elected to proceed on the lesser included evading just based on where his location was. He was on his own front porch.
Was it I put resisting, but I don't have a problem with going.
Either is fine. The facts are good.
So it's, which one? Y'all pick.
Resisting is fine.
Yeah, I think resisting
So-
is probably a lesser.
Lesser of resisting, is that a class A or B?
Hey.
You've got the third degree checked off on the
Well, that was
admonishments.
the original.
Yeah, we've got to admonish him to what he's pleading to.
Right,
Let's
that was
see.
the original admonishment.
Yeah. Class A. What's the max fine on a misdemeanor?
4,000.
Thank you. All right, Mr. Martin, in cause number, will he waive the formal reading of the indictment?
Yes, ma'am, he will.
Mr. Martin, in cause number 25, DCCR 0270, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest. And that is from January 29th of 2025. And how do you plead to that charge?
Let's just get it out the way and go home.
Okay, you just say.
What is your plea?
Guilty or not.
Oh, for the charge of resisting.
Of resisting arrest?
I'm just gonna go with
No, you don't get to just go with anything. Either you did it or you didn't do it. So are you guilty of resisting arrest or are you not guilty of resisting
Now, have a
arrest?
moment.
I'm gonna go with guilty.
Okay.
You don't get to just go with guilty, okay?
I was
You need to
guilty.
say, because here's the thing, you just got sworn in over there and you're under oath to tell the truth. And so I'm asking you some questions while you're under oath. So taking a deal just to get something over with isn't what we do here.
Yes, ma'am.
You either did it or you didn't do it. Do you understand? So to the charge of the lesser included offense of resisting arrest from January 29th of 2025, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes,
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford?
yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes,
And are you a U.S. citizen?
ma'am. Yes.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Martin is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor resisting arrest. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence. Have y'all checked that he has 180?
He's been in jail since January.
So you'll get credit on that sentence for any time that you've been in custody,
Yes.
that the law gives you the right to receive.
And I request some backup time.
Okay.
You get credit for any time you've been in custody.
Oh.
All right, so if you've been in custody since January, you'll get all of that time credit. Do you understand? I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Thank you.
Yes, sir. Okay. You can't tell. I don't know where this, no, I think it's a little better. I don't know what's happening. My computer keeps popping up. Oh. Is Mr. Young here? Okay. Mr. Young? Oh, wait, is he in the back? Okay, I'll call him back in a second without Mr. Vasquez. We've got Andre Williams.
Yeah, sure.
Good morning.
Good morning. How are you?
Good. How about yourself? Good morning, sir.
I'm all right.
I have 8 dead victims on today's docket.
There's a lot. We have a lot of.
No, I have 6. We have 8 total.
8 total.
So I have 3 murders and 3 manslaughter.
Yeah.
Okay, I'm actually about to plead one of the manslaughter.
Wow. All right, sir. Are you Andre Williams?
Yes, ma'am.
And in cause number 24, DCCR 1539, Mr. Williams is charged with tampering or fabricating physical evidence. And in cause number 24, DCCR 2286, Mr. Williams is charged with a first-degree felony offense of murder. And we'll get this pulled up because we had Mr. Williams examined for competency.
Yeah, sure.
And we've received that report from Dr. Grapon. Dated May 29th of 2025. The finding in that report by Dr. Grapon is that Mr. Williams is currently competent to stand trial. Is there any other evidence with regard to competency?
No, ma'am.
No, Your Honor.
Then at this time, I am going to find that Mr. Williams is competent to stand trial. Mr. Vasquez, what is the announcement?
Judge, I'm asking for 30 days. The reason being, there are some Social Security Administration records that I don't have, that I have not subpoenaed, have become aware of lately. A family member thinks they could be useful. I know the court sets trials out for probably 30 or 45 days anyway, but I'm just nervous about getting on the trial docket today without those records. I'd like to have them.
Okay, well, I'll give you one reset for that. Any issues?
No, Your Honor, we did do a rejection today before your offer, which I think we've done maybe once before.
Okay, so I'll just do a normal reset, which is about 30 days. Make
Thank
sure
you.
you get that subpoena done quickly, and that way you'll have what you need, and we'll get an announcement at the next court date.
Thank you.
Okay, you can go back with the bailiff.
Thank you, Luke.
Yes, sir.
Mr. Kimler, you have Melissa Taylor to sentencing. Happy vacation.
How's your vacation?
Good. If there are people in jail, show up.
I appreciate that.
He's here, I just talked to him. Difficult for me to assess the credibility of those without the opportunity to confront and cross-examine the witnesses, but taking them at their face value in here, of course, indicates a pattern of behavior that Ms. Taylor exhibited in jail that shows that she was not compliant. I would observe, though, that there is no write-up subsequent to July of 2024. I think she went back into custody in April of 2025. And has had no incident reports since then. I've been speaking with Ms. Taylor and trying to understand what was going on in the jail. I think that she was struggling with mental health issues while she was in jail during this stay when she accumulated these write-ups. She indicated that she was, after an assessment, psychological assessment, she was on around 5 different medications, including
Seroquel, trazodone, and lithium.
A veritable cocktail of psych meds during this. Judge, not to derail Mr. Kimler, I'm kind of in agreement after reviewing the PSI that what she needs is treatment and mental health.
Okay.
So
Well,
that may make the court's decision.
I'll cut that short there.
Okay.
We'll defer to, she wanted to address the court and I'll defer.
Go ahead, ma'am.
Yes, ma'am, I just wanted to piggyback off that. Those were during a state of psychosis with the meds that I was on. That this last 4 months that I've spent in jail, I've put myself through basically a mental rewiring of my brain chemistry through the literature that I'm reading, and I've had a lot of success with my behavior. My son has been reintegrated into my life again without his father. The family that has him, we're in contact every day, which has been tremendous for my mental health and is a key aspect as a woman yourself, but I'm sure mom. He was my identity for 12 years. And when he was taken, I lost my identity, and that was a huge part of this last year. But I don't want to look at this last year as being a victim. I want to be victorious over this and really turn this mess into a message. And I just hope that I get to be integrated back into society.
She is, what is the badge you're on now that's helping?
I'm on, it's oxycarbazine, just one medication now is all they have me on, and so it's been, yeah, it's just a mood stabilizer.
All right, well, here's what I'm inclined to do. Obviously, you were having the mental health issues and self-medicating.
Yes,
with
absolutely.
just about everything. It's okay. And so if I'm going to feel comfortable giving you a probation, it's going to be with some treatment, obviously. So I'm going to find in cause number 242177, find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in that case for a period of 10 years. You're ordered to pay a $500 fine, follow all of the rules and conditions of probation, and I'm going to go over some of those special conditions in just a minute. In cause number 242311, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in that case, place you on probation for 5 years. You're ordered to pay a $500 fine in that case as well and follow all of the rules and conditions of probation. One of those conditions is that you enter and successfully complete the Special Needs Safety Program. So that's a kind of a dual program where you're going to get help for any type of drug issues that you have in addition to mental health care. Once you get out, you'll be on probation and you'll be able to hopefully have the follow-up treatment, follow all of those rules, and be on the way to doing exactly what you're saying.
If I might, she has pending cases in Fort Bend County. She'd have to resolve those before she would go. So
do they have a hold on her?
yes, sir.
All right, well then, so what'll happen is you'll go to Fort Bend County, resolve those, and then you'll have to go to SAP after that, okay? So the sooner you get over there, resolve that, the sooner you can get to special needs safety and get back out and on track to do, again, what you say you want to do, okay?
There's no way that I could, that's it, like, in.
Yes, ma'am. It's the only way with this cap and with the history and with what's been going on that I feel comfortable. It's not meant to necessarily be a punishment. It is treatment up front so you can be successful.
You said it was 90 days?
6 months.
This is more, yeah, I think it's closer to 180.
With
Okay.
aftercare.
And then the aftercare is out, but you'll go to halfway out. You'll go, there's some step down after you get out where you'll be out doing different things, but following some very strict rules for aftercare, okay? So I'm going to hand you the trial court certification in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. Good luck to you, ma'am.
Thank you.
Peyton Woodruff, Mr. Kindler, it's a sentencing.
You discuss this in dialogue?
I had a note in my file, I checked. Probably be in my file. I haven't.
You don't have the cases yet? Intake of the time?
Not the drug case, no. I have to put something on the record.
All right.
Good morning, ma'am. Are you Peyton Woodruff?
Yes, ma'am.
And Ms. Woodruff was previously in court, entered a plea of guilty in cause number 24, DCCR 1710, to the state jail felony offense of burglary of a building, and in cause number 25, DCCR 0426, to the second degree felony offense of robbery. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
I defense station.
State has to.
Any additions or corrections to that report?
The only correction I observed, Your Honor, was actually, I think it's a typo where they talk about moral, the MRT program. And they reference it as recognition. I think it's recognition.
Okay.
Misspelled. It's not,
Yeah.
that's, I think that's the problem.
Okay.
Nothing from the state.
And Mr. Coleman has filed a sentencing memorandum as well as a request, states motion to accumulate any sentences. Is that correct? Mr.
That's correct, Judge. I'm inclined to withdraw that motion to you.
Thank you. All right. All right, Mr. Kimler, you may proceed.
Basically, Your Honor, I would defer to the pre-sentence report. It seems to contain all the information necessary for the court. In my mind, I'm not saying the court is bound to give her probation, but certainly the pre-sentence report certainly would tend, in my reading, to indicate that that would be the appropriate sentence here. I think paramount in that analysis is the defendant's recognition of her failures and acceptance of responsibility, which is clear from her rather articulate.
You can speak up, please.
It's just clear from her rather articulate expression of that in the pre-sentence report, where she accepts responsibility and seems to have enough insight and self-awareness to realize that she needs to make changes in her life to be successful. She has been successful in the past in light of criminal history, you can see from the report. And again, we would just refer to what appears to be the recommendation, the implied recommendation, I suppose, of the pre-sentence report to put her on probation.
Mr. Coleman?
Your Honor, just simply made his position clear in his sentencing memorandum. The series of events, notwithstanding her latter criminal history, but that criminal episode that she engaged in, whereby she received 4 felony offenses, a burglary, robbery, 2 possessions of a controlled substance, I think justifies a minimum jail sentence of 2 years on the robbery, judge, and a 24-month sentence on the state jail burglary to run concurrently.
The only thing I would observe, Your Honor, obviously that's a minimum sentence, and that would kind of be the easy way out. But the problem with that is it gives her felony convictions.
No, I'm not inclined. I mean, while I agree with Mr. Coleman that this was kind of a lot of things that happened very quickly, the lack of criminal history shows, in my opinion, that things were going on with regard to substance abuse and mental health, and I think this is a case that would be, I don't see any reason that there would not be a probation given that opportunity at least. So, Ms. Woodruff, in cause number 24 DCCR 1710, I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation. In that case, that's the burglar of a building, for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation, and I'll talk about those in just a minute. In cause number 25, DCCR 0426, also find sufficient evidence to find you guilty, but I'm going to defer all proceedings, place you on probation for 10 years in that case. You're ordered to pay a $500 fine, and you're ordered to follow all of the rules and conditions of probation. You will, when you're on probation, they will do a substance abuse assessment, and then they will recommend whatever treatment. And whatever that treatment is that they recommend, whether it's inpatient, outpatient, if they think you need something, then you will be ordered to do it. Do you understand?
Yes, ma'am.
Also, you'll get a mental health assessment to see if there's anything that you need there to help you be successful. You will be ordered to follow all of those rules as well. You are to have no contact with the victims of the offenses. That's a Toni Morrison and Logan Kotlerich. Also, what is the relationship with John Toops?
He is my ex-boyfriend.
He's going to remain your ex-boyfriend. So you will have no contact or communication with him either. Do you understand? And so if you do everything that you're supposed to on these probations, this is an excellent opportunity. You're fairly young, you don't have criminal history. Obviously, you were going through, like I said, substance abuse issues and mental health issues, and you went all in pretty quickly. This is your opportunity to not be a convicted felon and to be able to serve any sentence while you're out on probation. The downside to that, though, is if you violate any condition of probation at all, you can be brought back into court, you could be found guilty, so you would be a convicted felon. And in the robbery case, you could go to prison for up to 20 years, and in the burglary, up to 2 years. Do you understand?
Yes.
I'm going to hand you, in each of these cases, the trial court certifications that shows that these were not agreements, and so you do have some rights to appeal. You can talk to Mr. Kimber about that. Yes, sir?
Your Honor, there's the matter of a pending drug case.
Yeah.
She was arrested on July 21st, 2024, somehow our office has obtained a lab report from that case, but not the actual case referral. About 2 weeks ago, I put in a call to the sheriff's department, the narcotics department there at the sheriff's department, judge, and apparently returning phone calls is an outdated concept because I've not received a phone call back.
Welcome to my world.
Yeah, I was asked to leave a message for Donna in narcotics, and she has to date not returned my phone call. So the Jefferson County, BPD, not Sheriff's Department. So the BPD case number is 2024-14337, and this disposition of these cases is intended to dispose of that case as well.
So if it does come into the office, you're going to not
Decline.
So that's the 2024 one. What about the 2025 case?
Well,
The
There's two
PSI shows two. The PSI shows that July one from 2024, but it also shows a March of 2025.
I'm not aware, of that one just, is there a case number of this?
No, it's just listed.
I don't have any heartburn over declining that one as well, Judge. It's just I don't have a case number to put on record or anything like that.
Okay, if you'll just kind of watch for it, then we'll hopefully catch it. Y'all can catch it before it.
If the court wants to construe that as an agreement, then we would waive our right to an appeal. If that wants to be, I mean, if we have an agreement that they're not going to be.
Well, that's what we would need to change all the paperwork. That's done. I can't imagine that getting a probation, there's going to be an appeal issue anyway. So, all right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
Yes, ma'am. Mr. LeBlanc, you have Marcus Austin. Okay. Good morning. Good morning, sir. Are you Marcus Austin?
Yes, ma'am.
And cause number 24, DCCR 1942. Mr. Austin's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, I believe we were coming here before. I think we've been announced already. I believe, I'm speaking to the prosecutor, understandably. There may be another case.
I can't hear you.
There may be another case that's, I don't especially set, but I need to.
Okay.
Court.
Are you ready, Mr. Nichols? Okay. Obviously, I do have another one that we intend to go forward, but things like that change all the time. So I want to make sure Mr. Austin previously, hold on, rejected an offer in February. It was a 35-year sentence. This is an aggravated assault, family violence with a weapon. 35 years was the offer. Nothing's changed with the part of that.
That offer will not change.
All right, and you want to go forward with your trial?
Man, you getting come down on something?
We're not here to negotiate. Mr. LeBlanc, I'm sure, has been negotiating with the district attorney.
And Mr. Bond's got with me several times asking if there was any wiggle room, and I've told him strongly no on every occasion.
Okay, so there's your answer. It's 35 years or go to trial. So do you want to reject that and go to trial and let a jury decide? Or do you want to take the 35? What? All right, I'll hold it while y'all take care of the paperwork. What about Lenny Leday? Sometimes it helps when they hear it out loud from everybody that this is it. Oh, well, I don't know. That sounds very reasonable. Oh. Pick Burger King. You get it your way. Or not. Good morning. Are you Lenny Leday?
Yes.
And Mr. Leday is charged in cause number 23, DCCR 0783 with the offense of sexual assault. And what is the announcement?
Judge, I need a little more time. I mean, he's made an offer, I think, with the prior, I think the court made note, the prior attorney, I'm speaking with Mr. Radford, he's got some things in his file that I need to look at.
Okay.
And I just found that out, so I need to get with him. I mean, you can set it on, I believe this is an older case, even though I'm new on it.
It is, and it's gone through some attorneys. And so I'm going to give you 30 days. You need to take all that time, get completely caught up so we can get an announcement, visit with Mr. Radford, Mr. Hofftower, and then I want an announcement at the next court date.
And I believe the announcement's gonna be trial. I mean, it's
Sure.
trial. So that-
I just want to make sure you've looked at everything and that you go over it with Mr. Leday, even though other attorneys have. Y'all go over everything again, talk about consequences, options, and then we will get an announcement. And if it's a trial announcement at the next court date, we'll get it on the quickest trial docket, okay? You can go back with the bailiff.
Okay.
Okay. Mr. Young? Good morning, sir. On Salvador Gomez?
Salvador, go ahead.
How are you, sir?
I'm well, how are you?
Good, thank you.
The only thing I caught in the motion was about pictures and video. It's just like I was getting.
Good morning, you're Salvador Gomez. And Mr. Gomez has 3 cases, 2 intox manslaughters and a driving while intoxicated, set for trial for jury selection next Monday afternoon. And what is the announcement? Is everybody ready?
Yes, Your Honor, state's ready. I know Mr. Jones ready. We discussed and we asked for a special setting and everyone's, as
Right.
far as I know, ready to go.
Okay. Anything, it looks like there was a motion in limine filed recently. Any issues that we need to take up today with regard to that, or do y'all want to handle it Monday before we get
Probably
started?
Mondays. Judge, it's pretty standard. It's about showing graphic video or pictures. The only issue is in this case, there's really, everything's going to be graphic. And I will do my best, as you know, I've done in the past, to cut it down. I don't want to inundate the jury or the audience with gore, but it's a double fatality that ended up fiery crash. So I mean, I don't have.
Obviously,
pictures
some
that
will be
are graphic.
necessary, but we can go over at the time any limitations that,
We'll be
during
as
that.
reasonable as we can.
Okay.
I think we just, ask that they articulate the probative value. of it,
Sure.
Because I think there are a lot that probably,
Certainly.
especially given that I don't know if we're really contesting intoxication or causation. While he hasn't finally made his decision, we still anticipate pleading guilty to the jury.
Okay, and just going forward with punishment.
And in that regard, Judge, I have an election for punishment and an application for community supervision. Can I file those with the court, or would you prefer that I file those electronically?
It's so much easier if you do it electronically.
I'll just do it now.
Otherwise, they have to do it electronically for you, so.
I'll take care of that when I.
Perfect, thank you. And if you need, on the application, the clerks, while you guys are here.
She did it for me
Already
last
did it,
time.
okay, perfect. All right, anything else then?
No, Your Honor, I think everyone is prepared to move forward.
All right, we'll see y'all.
As far as scheduling, Judge, because I know his wife and his kids are frankly all working now, and so I'm assuming if I have him here Thursday morning, does that sound probably when you'll be done?
I would aim, I think that's reasonable. It's always hard to say.
I know it's hard
I
to
would
say.
rather, it's hard to say, I know for all of you guys, I would rather, and I know if they're working, we don't want them to miss too much work. I would rather them be here possibly a day early, just in case. What I don't like to do, if I can avoid it, is have a jury have to leave at 2:00 some afternoon because we don't have witnesses ready. So maybe Wednesday noonish would be, and they might have to wait, and it might be the next day, but I'd rather that if we can.
And I assume we'll pick the jury Monday, start evidence Tuesday?
Correct. So what we'll do, I have just like this week, I have this docket every Tuesday morning. So we'll pick the jury at 1:00 on Monday, and then on Tuesday, we'll actually start trial at 1:00.
Okay.
So because I can't really skip this docket every week. And so, and then we'll go regular times, pretty much 9 to 5 the rest of the time. Okay?
Thank you, Judge.
Yes, sir. If you need anything else, I'm sure Mr. Nichols can help you out, or call the clerks if you need anything
We've
about
been in
how we do
contact, Your
things
Honor.
here or whatever. Okay, perfect. Thank you. We'll see y'all Monday.
Thank you.
Mr. Rojas, you've got Stephanie Moore. It's a sentencing. I took this off of something and didn't put it back on. Probably one of my sentencings with a lot of things. Good morning, Mr. Rojas.
Good morning.
Good morning. You are Stephanie Moore?
Yes, ma'am.
And so Ms. Moore is here in cause number 11-12536, on probation for the offense of robbery. That probation was from December 8th of 2011. And we were here. She pled true to count 1, 2, and 3 in that motion. I've received an updated pre-sentence report. And has everyone had an opportunity to review that?
We have, Your Honor. I have, Your Honor.
That also includes a letter from Ms. Moore and a substance abuse evaluation as well that was done at one point. Do y'all have that as well?
I do, Your Honor.
Okay. So this is open to me, and I know we all understand the predicament that we're in. I mean, I have two choices. I can revoke or it just goes away.
That's correct, Judge. And with a 7-year period of absconding, I don't know what the right answer is. I did look up, and I'll note for the court that she's been in jail 111 days since this motion was filed, or since she was apprehended, and a total of about 270 days on this case. I just think we can't ignore that period of just abandoning probation. I'm not advocating for a heavy sentence, but I think revocation is what we kind of have to do here.
I don't disagree.
I understand if the court feels differently, but that's...
No, I don't think I do, because I mean, it looks like, I think that's just kind of rewarding some really bad behavior.
I understand that, Judge. I think from Ms. Moore's perspective, I mean, she had been going along up until 2017, doing relatively well on probation. She tells me that in 2017, when Hurricane Harvey came through, she just had 20 feet of water in her house, and she just spent the rest of that time trying to recover from that. I think
I did call my probation officer and try to get him to help, but he never even came out to my house or nothing. He didn't help me get any kind of mental health help or anything, and I called my old one, which was Miss Sally, and nobody came out for help.
You were on the mental health initiative caseload. You've been to the Franklin House South, the Oxford House for Women.
Yes, I was the president there.
Through the ATAR program,
Yes,
through
ma'am.
Right Choice, through SafeP, and you were a resident at some point at the Jefferson County Women's Center.
Yes, ma'am.
Okay. I mean, that sounds like a lot of help.
I did. Well, I did all that and did good with all that.
Okay. Okay. Anything else?
No, Your Honor.
Judge, I think, I know the court doesn't like to do this, but I think there may be another option. Maybe if the court, because one of the allegations is that she's behind on her fees.
I'm not worried about that. I'm worried about 7 years of doing whatever she wants. And I understand that Harvey affected a lot of people, but then you get over whatever is happening and you go see your probation officer.
Okay.
You don't just stop
Yes, ma'am. I
for 7
understand.
years. Okay, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of robbery. I'm going to sentence you to a term of 3 years in the institutional division of the Texas Department of Corrections.
Okay.
You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need y'all to sign this. I'm going to, this is the trial court certification, if you'll get her signature, that she's getting a copy of that real quick, please. Thank you for being here, Ms. Joseph.
Thank you.
Sorry, I didn't ask you if you had anything else to say. So you're going to get a copy of this, which shows that this was not an agreement, and so you do have some rights to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
Good luck to you, ma'am.
Thank you.
Let's see, Naya Miller, Mr. Rojas.
I signed it. 1 year, 1244. See? When they have a file, there's no these things. Anna, be over Harvard?
All of a sudden, not all of a sudden, I'm sure I pushed a button, but now on here, it's not in lawyer order anymore.
I'll work on it.
Well, it's just gonna, hold on. Now give me just a second. Now what? Nope, I'm ready. I don't know what I could have, how I did that. It's okay, I'll deal with it for now, and then we'll figure it out. Okay. Let me find it. Are you Naya Miller?
She's hard of hearing, Joseph.
Okay, can you hear me?
Yes.
Okay, and are you Naya Miller?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor. It's actually a motion.
Oh, okay, of the motion, I'm sorry. Stand up, ma'am. Ms. Miller, in cause number 24-2227, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 14th of 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed January 16th of 2025. And is that true or not true?
True.
Count 2 alleges that you did not provide verification of performing the community service hours. Is that true or not true? True. Count 3 alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Miller is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. You cannot for some amount of time. If you have, you should read that document. It'll explain that to you. If you have any questions about it, you can talk to Mr. Rojas to find out how long it lasts and what all that rules are. But you can read that document. It has the information. All right, do you understand?
So when my
chime in, do I still have more time to do?
I don't know how much credit you get, but you will get credit for any time that you've been in custody that the law gives you the right to receive. They'll figure out that later today, the clerk will, and send it over to the jail. Okay? You can go back with the bailiff. See Bryce Bordeaux to sentencing, Mr. Rojas. What is it on the motion on this one? Oh, no, I need to write on it. It's back in order now. No, it's not. I'm just kidding. It's not. I don't know either, but it's not. All right, so are you Bryce Bordeaux?
Yes, ma'am.
Mr. Bordeaux was previously in court, cause number 25 DCCR 0444, entered a plea of guilty to the second-degree felony offense of robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. Yes, Your Honor.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
All right, Mr. Bordeaux, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be that you will be required to enter and successfully complete the JCDI program. Everything in here points to the fact that there is an alcohol issue. And so you're going to get treatment for that, and it will be part of your probation. You are not to drink any alcohol on probation. You will also be required for some amount of time to wear a scram device. That will show if there's any alcohol in your system. If there is, it's a violation of your probation. So you need to take advantage of the treatment and whatever they have to offer you. Do you understand?
Yes, ma'am.
If you do everything you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case actually gets dismissed. You'll never have a felony conviction.
Thank you.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon, and you could be sentenced anywhere in that range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Okay.
Thank you, Your Honor.
Yes, sir. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you.
Please click where it says Tuesday jail docket, Tuesday jail docket, click.
Attorney down there, see, I knew it. There's no way you could have changed that. Oh, I know where it is. Hold on. I got it. Okay. All right. So, Mr. Flemings, Mr. Radford has said that you have changed your mind and you want to go forward with trials. Is that correct in both of your cases? And I want to make sure you understand, and I know Mr. Radford has gone over it with you, that the way the law is right now, if you are found guilty and if those prior convictions are proven to be true, then you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life in each of those cases. Do you understand? And you want to reject that 8-year term and have your cases set for trial. Is that correct? All right, we'll get them set on the next available trial docket, and Mr. Radford will begin preparation for trial.
Yes, ma'am. Thank you. Can I make a excuse?
Yes. Mr. Parker, you have David James sentencing hearing. Good morning. Are you David James?
Yes, Your Honor.
All right, so Mr. James was previously in court and entered a plea of guilty in cause number 25 DCCR 0522, which is the third-degree felony offense of collision involving serious bodily injury, and then entered pleas of true in the burglary of a habitation case, cause number 1523545. Looks like there's an agreement for a 10-year term, probated for 5 years in the collision involving serious bodily injury, and then an agreement to extend the probation for 2 years and order the Safe P relapse program. Is that correct?
Correct, Judge.
So I guess my main concern from reading all of this, a couple of things. Number one, he tested positive 2 weeks after completing Safe P when he got out. And so that gives me obviously some concern. There sounds like there are some mental health issues that potentially special needs Safe P would address. And so what I'm more inclined to do, if I'm going to follow this agreement, would be regular, not the Safe P relapse, but the special needs Safe P, and go all the way through the program again from the beginning. I just think that
He has admitted that he needs the help, Judge.
So, I mean, here's the thing, Mr. James, most people don't get 2 shots at Safe P. And y'all have reached an agreement for that to happen. And I'm inclined to go along with it, but I want to make sure you understand, this is it. I mean, if you don't, how old are you? 61 years old. It is time to get the tools that they give you at Safe P and use them when you get out. It's easy when you're in custody, but you've got to use those tools that you're given. If you don't, then you're going to end up spending a lot of time in prison. Because if I do this today, you have already agreed to a 10-year term. Do you understand?
Yes,
Okay. All right, then I'm going to find in cause number 25 DCCR 0522 sufficient evidence to find you guilty, and at this time find you guilty of the collision involving serious bodily injury. Sentence you to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 5 years. I am going to order a $500 fine in that case, and that you follow all of the rules and conditions of probation, which will include entering and successfully completing the Special Needs Safe P program. In cause number 1523545, I'm going to find that you entered your pleas of true to counts 1 through 7 and then 9 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke that probation. However, I'm going to continue you on probation, extend the probation period for 2 years. Also order that you enter and successfully complete the Special Needs Safety Program, and then obviously get out. You know what happens. You're on, as soon as you get out of safety, you're given tools to go to the whole treatment program that's outpatient. And so you need to take advantage of all of that. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you have waived your right to appeal. Good luck to you, sir.
Okay, thank you.
Mr. Parker, you've got Jacoby Lawrence. You okay over there? Yeah, it's missing a TRN, if anybody was wondering.
Yeah, you put up there. Oh, does she want the discovery, Judge?
Let's see, are we going on count 1 only?
Yes, you are. If I didn't mark it,
And then you probably did, I just haven't looked at it. All right, sir, are you Jacoby Lawrence?
Yes, ma'am.
And Mr. Parker, will he waive the formal reading of the indictment?
You will, Your Honor.
Mr. Lawrence, in cause number 25 DCCR 0656, the state has elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of harassment of a public servant from March 28th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Lawrence is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have also handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Also, you've been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Nicole Sanchez, Mr. Parker.
Pleading 1, dismissal 0.
Thank you. Good morning, ma'am. Are you Nicole Sanchez? And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Ms. Sanchez, in cause number 24, DCCR 1988, you're charged with the state jail felony offense of possession of a controlled substance from April 23rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
So, I know on a state jail felony possession, if it's a first, it's required probation. Is it not required deferred on the first? From my
You know
drug
what?
court days, I think it's,
You're right, Judge.
it has to be a deferred probation. It's required by
correct.
law on a first possession.
Good case, too.
Okay, so with everyone's permission, can I make that change on their agreed punishment recommendation, that it would be a 5-year deferred?
Yes.
Okay, Judge.
Thank you.
I forgot all about that.
You don't have another felony conviction anywhere, right? Okay. Okay, so the agreement then,
Sorry, she does have my notes reflected 2013 manufactured delivery in which she received 2 years probation. I don't know if that would count towards being prohibited from the deferred, which went into my calculation for offering a straight probation
Sure.
this time.
15 years ago, you told me I wasn't voting.
Okay, then I think it probably would change, that can be straight, and that was, so I'm going to change it back to what y'all's agreement is. Thank you, Mr. Coleman. Okay, so the agreement is that you would be convicted, there would be a 2-year term in the state jail prison, but that would be probated for 5 years. There would be a $500 fine. You would be required to follow all the rules and conditions of probation, and there would be a dismissal in cause number 24 DCCR, wait. 1118. Okay, is that your understanding? That means the fraudulent use or possession is getting dismissed. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanchez is not competent?
No, Your Honor.
And Mr. Coleman, other than that, is there anything else that you see?
That's the only criminal history that.
We'd like to waive the PSI, Judge.
Any reason not to?
No objection to waiving the PSI.
We'll get a post-sentence report done. Ms. Sanchez, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you will be able to serve that 2-year term while you're out on probation instead of in the state jail prison. The other side of that is if you violate any condition of probation, you can be brought back into court and you'll get that 2-year sentence that you've already agreed to. Obviously, there's an issue if it's a possession case with drug issues. And so you will have an assessment done when you start probation. And as part of your probation, you're ordered to follow any recommended treatment programs. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Parker. Good luck to you, ma'am. And I will sign that dismissal now in 1118.
Okay, so guys, thank you so much. Thank you.
Yes. And a jury decide 2 things. The first is to decide if you're guilty or not, and then you could leave your punishment up to them if you're found guilty. By going forward this way, you're waiving that and you're leaving it up to me. As long as I give you 50 years or less, then you're waiving that right to appeal. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. James is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done by probation. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. And we'll see you at that sentencing hearing. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Honor, we did have a scheduled hearing at 11 with witnesses. I'm not going to need to call witnesses today.
Okay, let me take care of the rest of what we got and then we'll get to it in just a minute. And is Todd LeBlanc back there working on something?
He texted him, he has an answer for me.
Todd LeBlanc in the back?
They're doing a dismissal of the state's motion in that case to revoke. We have an agreement, I don't know if we need paperwork on this, for a 30-day sanction of the defendant and continuing on probation. The underlying criminal offenses have been either refused or dismissed. And then there is a criminal offense from Harris County that I've not been able to determine.
I've been informed that that will be disposed of as well with the dismissal, but it has not happened yet.
Okay, so I will sign the motion to revoke dismissal as soon as it comes through. I will order the 30 days upfront time, or 30 days as a sanction, as the agreement that he gets credit since he's been in custody on this. Okay, all right, we'll get that done. And probation, if I need to sign something, I can get that signed today for the 30 days. All right, good luck. Make sure you're on probation, follow all of those rules and conditions, or you're gonna end up right back in here. Okay, you're free to go back with the bailiff. Let's see, Jordan Thomas, is he on?
I have filed a request to reduce bond.
Jordan Thomas,
It's Kobe's.
it's Mr. Hoffpower's case.
Yeah, he said he's gonna dismiss them too. It's, I found a motion to reduce bond on the sexual assault.
But I think Kobe stepped
I
out.
talked to Kobe.
We can grab him, 'cause I'm.
Okay, I'll hold it till he comes back
Stand
in.
here for some of these arguments.
Yeah, I talked to him.
Oh, you did? Okay, good, thanks.
Who's Andre Williams? What am I missing? I have a plea bargain rejection up here, but I don't have, all my pages are folded up like I've got. Andre Williams? Bless you, bless you.
Joel. Maybe he did on that, but we already took care of it.
I did reset them, so I don't know why. I'll just delete it. I
Wanted, think about, discovery stuff.
don't know why he did that. I'm gonna delete that.
You had to do it with Tina.
Okay, yeah. So I think, all I show then is Jordan Thomas and then the one that they have at 11, I think.
And I'm trying to find out about.
Todd LeBlanc, yeah.
So this is how old that Cosmo is on that rig. I don't know if the system will pull it up. I mean, I was here when that Cosmo was done.
Any health number that's ever been able to what?
I mean, can we put it on the tablet for the state, because Judge Grant read it? That might be the DA number.
I was thinking about that case y'all had last week, had a mistrial.
Those, they're both deferred probations, one for possession of a controlled substance, the other for evading arrest or detention with the use of a vehicle. Mr. Briscoe was previously in court, entered pleas of true to counts 1, 4, and 5. We reset this for a hearing. I have received the pre-sentence updated report. Does everyone receive that report?
We have, Your Honor.
Yes, we have, Your Honor.
And go ahead.
I'm just gonna let the court know, after reviewing the probation officer's report, I'm in agreement with the recommendation of ISF. I don't see a problem with that based on the information provided.
Okay, and no witnesses or with regard to any of the other
Not
counts?
gonna need to, Your Honor. He pled true to one concern is that there's a drug offense pending that's not yet been filed, it's still awaiting testing.
Okay.
We'll try to catch it as soon as we do and either run a concurrent or we'll we'll deal with it. It just hadn't been brought to us yet.
Okay.
There's misdemeanors pending that,
He's
we've
taking
discussed.
care of it.
He's gonna take care of it
License
as
here.
soon as he, is done here, they'll free him up to be sent off.
And what I'd like to say, just from his benefit, there was a charge of the possession of a controlled substance, and there was a pack of cigarettes that he picked up, and he says he picked up the wrong pack of cigarettes. It was a female that I think lived with him at the house, and they had had issues. He had tested clean for 3 years, I believe, or for some time, and was even tested a couple of days after this. He said he picked up the wrong pack of cigarettes. She had been trying to get him in trouble to get rid of him. So just, not that it has an impact on this, but that's.
Okay. Well, sounds like if somebody's trying to get rid of you, you just need to leave, right?
Go.
Okay. All right, Mr. Briscoe, I'm going to find that you previously entered your pleas of true to counts 1, 4, and 5 in each of your cases, freely and voluntarily. Find those counts true. Find sufficient evidence to revoke both of those probations, but I'm not going to do that. It sounds like probation is willing to work with you and that they have reason to believe you can be successful. So I am going to extend your probation for 2 years. You will be ordered to enter and successfully complete the cognitive track of the Intermediate Sanctions Facility, the ISF program. You'll be on the high-medium caseload and be required, obviously, to follow all of the rules and conditions of probation when you get out of ISF. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
I congratulated Burbank on, he's always stressing me, so I said, congratulations on getting a guy to jail time, but you ain't probation on one of the cases.
Oh.
He's like, oh, thanks.
Uh-huh. Here's that. Oh, sorry. Okay, Jordan Thomas. Okay, are you Jordan Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 24 DCCR 0487 with sexual assault of a child, and in cause number 24 DCCR 2178 with aggravated assault with a deadly weapon. And Ms. Holmes filed a motion to reduce the bond. Is that in each of his cases?
And just the sexual assault.
Which is $100,000 in that case presently. And I know this was recently filed. Mr. Hoffpower, are you ready to proceed on that, or do you need time? All right, Ms. Holmes, do you intend to call your client?
Yes, sir.
Mr. Thomas, please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You may proceed.
Thank you. Your name is Jordan Thomas, correct?
Yes, ma'am.
And Mr. Thomas, how long have you been incarcerated at the Jefferson County Correctional Facility?
9 months.
9 months. And in those 9 months, has your bond been set at $100,000 for the offense of the sexual assault?
Yes, ma'am.
And has your family during that time tried to inquire about helping you make bail, but have been unable to due to the amount of it?
Yes, ma'am.
And do you have any property at this time or anything of value that you could sell that could arise to the amount to be able to bond out at $100,000? Okay, and have you all worked diligently within these 9 months to try to get that done, but have not been able to?
Yes, ma'am.
And are you asking the court to reduce your bond in an amount reasonable, and that you will abide by any conditions, and also whatever court appearances that you will be present, and that you will not be a flight risk?
Yes, ma'am.
So there was a bond forfeiture for non-appearance. That's why it's at $100,000 back in June of 2024. Why'd you miss your court date?
You got no answer.
Okay, you just didn't feel like getting up and coming? I mean,
No,
so
not-
she's
that
asking
too,
me to
I didn't have
reduce,
Transportation either, but,
I can't hear you.
I had transportation. I stayed home for. I tried to come, but
Did you call anybody and,
I called the bell. I called the bell when I was coming. I told them probably wouldn't make it. They told me to, turn myself in. So, the day of court, they wanted me to turn myself in
right?
after I missed the court date.
Okay, so why didn't you, when did you do that?
I believe I
Did you
turned-
turn yourself in, or were you
No,
arrested?
I turned myself in
When?
December 19th.
So you decided between June and December, you would just kind of hang out and see if anybody caught you knowing there was a bond forfeiture?
I didn't know it was a bond for it.
Well, if you don't show up for court, you don't get to just not show up for court and not have any consequences and just chill out and wait till whenever, right? Mr. Hoffpower,
I don't have any questions, Judge, just arguing.
what's your position?
My position, Your Honor, in light of 17.15, danger to community, just on the original charge, which we're here today on sexual assault, like the bonds would be high sufficient because of, due to the allegations and due to the danger of children in the community. Also, I want to add, obviously, the court knows there's another case that is before the court in yours, and it is another serious, dangerous felony. It was committed while he was on bond and in bond forfeiture on his sexual assault case. So that he proved my point.
So
I know it's like similar actions, but it is.
the offense date on the aggravated assault with a deadly weapon is from August of 2024. And so, hold on, when was the bond forfeiture?
June.
July.
No, you said June, July.
June of 2024.
I don't know why he wasn't arrested. He was arrested, or I don't know,
Why,
because the police interacted with him.
there
that
should
night.
have been a forfeiture and a warrant on the other case at that time as well.
Yeah.
So while you were out on bond is when this new allegation allegedly happened. Let me look at the PC on that one as well real quick.
August 18th.
Oh my gosh, I can't find anything on here. There was a warrant. I don't think he was arrested. This shows the Capia's return was from December, so that's when he turned himself in, probably on both of them.
I apologize if I
Yeah.
represented something different.
No,
That's
I'm
not
just
me.
saying, I don't think he got, I think that's, hold on a second, I can't read this, I gotta print it out. I'm printing the PC.
Oh, yes, how many plus?
Okay. Your motion's denied. Based on the fact that you were out on bond and allegedly committed this offense, which gives me some concern, which is the aggravated assault with a deadly weapon, and you missed your court date and really have no good reasons why or what you were doing other than potentially getting new cases, I'm going to leave your bond at 100,000. You can go back with the bailiff. We'll get an announcement at the next court date.
Yes, ma'am, thank you.
Thank you.
So anything from Todd?
has an open floor plan, so the kitchen, dining room, and living room are all open from one end to the other.
What happens after the defendant has ordered both you and your wife to sit down in the kitchen by the fridge at gunpoint?
Well, she stood very close to us, leaning against our stove, and kind of took control of the whole situation from there, and stayed there pretty much the whole time, and had in a very aggressive way had conversations with us, and yelling at us and accusing us of things, and doing several things throughout the night. She was also, it was very clear that she she wanted to be in charge, and she was in charge of the two other defendants.
Objection, speculation, yeah. Sustained.
Can you tell us what she was saying to the other two?
She was saying things like, she told them to get my father-in-law and bring him in the kitchen. There were a few things she said that I didn't necessarily hear, but I remember her being upset with one of them doing something that she didn't like, and she kind of corrected them, or yeah, and things like that, telling them to go upstairs, things like
Do you know why she told them to go upstairs?
no.
Okay.
And she also, at the end of the event, there were things like my dog was right next to me, because he was a puppy and he was very afraid, and she ordered them to come and grab the dog and take him outside. She also, towards the end, brought her daughter and told them to bring her outside, and she had to come get her coat and actually walk across us to get her coat. And she ordered the two men to do those things.
Do you remember anything else she might have ordered them to do? Okay. I think you also said she was yelling at you and your wife, maybe accusing you of things. Did I hear that right? Yes. Can you tell us the things that she was saying that you remember?
So specifically, she was focused on one particular accusation related, and she was focused on my wife, accusing her of not letting True believe in God, and basically calling us evil and demonic and things like that, because we wouldn't let her believe in God, and just calling us evil people, that we were a part of the system, that we all took her daughter, and things of that nature.
Is that true, that you didn't let True believe in God?
Absolutely not. The irony of it is it's the opposite, because my father-in-law is an ordained pastor. My wife, up until she became a full-time mother, she also was an ordained minister with the Assemblies of God. We attend church every Sunday morning and every Wednesday night. We brought full girls to church. They were involved in kids' church and Sunday school. Every night, part of our bedtime routine is we would sit down and read the Bible and read one or two books with each girl. before we went to bed, and then even for true, even tucking her into bed at night. She slept on a loft bed, and I would, either my wife or I would stand there and we would sing Christian songs to her to help her go to sleep.
How were you and your wife responding to this assault, to being yelled at and gun pointed at you and accused of things?
There's actually hearsay as to what the wife said.
Judge, any of it would be an excited utterance, present sense impression. He's there, just asking for how they responded.
Overruled.
Thank you.
Yeah, go ahead.
So, it was very, very interesting. I sat there and I remember looking, I was right in front of the garage door, and I remember focusing on the hinge of the door, and I thought to myself, and I was praying, and I thought to myself, why am I not afraid? And I was kind of surprised at the fact that I wasn't obviously I was afraid, but I wasn't terrified and afraid like you would think. And I attribute that to my faith in God, and that He was helping both of us, all of us that night. But I tried to stay relatively calm, and I noticed my wife, some of the responses that she was saying. We were trying to, in a calm way, try to de-escalate the situation and try to answer the accusations and explain some of the things that she was saying to us, that she was obviously misunderstanding something or believed something that wasn't true. And I was trying to cooperate with some of her demands related to the money, and just trying to calm the situation down and hoping that she would just leave. And my wife, my wife is probably one of the most non-confrontational people that I've ever known. She doesn't like conflict, even if it's something simple. But she too tried to remain calm and answer in a way that she was trying to calm Ms. Vincent down and respond cooperatively as to not aggravate or provoke in a calm demeanor.
Did any of that work?
It seemed to agitate even more. Anytime we would say anything, try to explain, it made Miss Vincent even more upset and more aggressive.
Did she at any point talk to you about some kind of a plan?
Yes, the beginning of the conversation, she was making these assertions about, in a very aggressive way, how she would use words like, I'm a gangster and I've planned this all out. And she stated things like, I don't care if I spend the rest of my life in jail. I still have the ability to harm you, even behind bars. Made statements like that, and it was very clear that she wanted that she was in charge and that she wanted us.
Speculation. I'm gonna overrule that one. I think he's been enough foundation as to what his conclusion may be. Go ahead.
Yeah, so it was clear to me that she wanted us to believe that she had power over us, and that she was not just some person who just did this on a whim, that she had been planning it, and and that everything that she was doing was orchestrated in a way, and in a way that seemed like she was trying to intimidate us further and make us afraid.
I believe I heard you testify a moment ago that at some point she also brought up money. Did I hear that right?
Right.
Tell us about that.
So at one point after, getting through the conversation, we call it a conversation, but getting through a lot of the accusations and all that, she turned and said, where do you keep the money? And my response was that where I was sitting was, as I mentioned, was right in front of the garage, the door out to the garage, and on the wall I keep my keys and my wallet right by the door. And so I told her, I said, well, my wallet's right there. I think I have a couple $100 in it. Said, please, take that. I mentioned, we just had Christmas, so probably the most expensive gift we got for the girls or for my daughter was a Nintendo Switch, which was $300 or $400. So I said, I mentioned that. I was like, there's a Nintendo Switch, you can take that. And she wasn't interested in that. And I think even one of the other defendants kind of laughed it off, like that was, they didn't want anything to do with that. That wasn't, real money. So she said, where's the other money? And we don't have a safe with thousands of dollars in it in our house. So I said, it's in the bank. And somehow the conversation turned to how can we get that money? And I said something, I said, I have a Venmo app, but I believe that the limit for transfer is like $500, something like that. And I said something along the lines that, even if I were to go down to the bank to try to get out a large sum of money, it would, from my understanding, it would be a process. It wouldn't just be them handing me a lot of money. It's a large amount, so I was trying to say, I don't know what you want me to do per se. And so at that point, she took my wallet and the credit cards, and she already had my phone. She took all of our phones when she had us sit down. And so she stood there with the gun in one hand, my phone in the other hand, and she demanded me to give her my bank password. So she stood there for however long it took, and I found out later she transferred a total of $6,000 out of my account in two transfers, one for $5,000, for $1,000.
Through the use of a particular app?
Yeah, it was through Zelle, because I guess, which I didn't know, that Zelle can have a higher amount to transfer.
At some point, did you get your wallet or did she get your wallet?
Yeah, she took my wallet and took the credit cards out of my wallet.
If you said that already and I missed it, I apologize.
Oh, no.
So you watched her take your wallet from the shelf and take the credit cards out. Your Honor, may I approach the witness?
You may.
Thank you. I am showing you two pictures. They are marked as people's proposed exhibits 3 and 4. Are they pictures of things that you recognize?
Yes.
What are they pictures of?
They are pictures credit cards that belong to me and my family.
Are those the credit cards that you just referenced that were taken by the defendant from your wallet that day?
Yes.
Okay. And those are fair and accurate representations of what those cards look like?
Yes.
Thank you. May I approach again, Your Honor?
You may.
Thank you. Mr. Bernhardt, I'm now showing you what's been marked as People's Proposed Exhibit 5. That's also a picture, correct?
Correct.
What is that a picture of?
Picture of some jewelry and watch.
Do you recognize that jewelry and watch?
Yes, the jewelry, the earrings, are pictures of earrings that my wife had and wore. The watch is the watch that was mine, that was upstairs in our bedroom.
Were you aware of those, start that. Is that picture a fair and accurate representation of those items that you just described to us?
Yes.
Okay. Were you aware of any items being taken from the upstairs of your home that day, that night?
At that point, I was not aware.
Okay. Did you give permission for anybody to take any of those things?
No.
Did anybody else in your presence give permission for those items to be taken? What happens after the defendant has taken your credit cards, has your phone, and makes $6,000 worth of a financial transfer?
So there was a couple things that happened during that. One of which, going back to the response that I made as far as how we responded during that time, there was something that I said trying to answer a question or trying to de-escalate, where I must have said something that was wrong or that made someone upset, but the first violent act was I was hit the forehead right on my eyebrow with what I believe was the butt of a weapon.
Who did that to you?
I believe it was Ms. Benson.
And I'm sorry, when in that process did that take place? At some point when you were sort of.
That was kind of early on. The one thing about this whole night is I kept thinking to myself, why are they still here? The amount of time that they spent in our home seemed like a very long time for somebody just coming in, you know, to take their daughter. And I kept thinking, why are they here? So this felt like a very long time. But that first initial act of violence was the first thing that happened. So that was probably during the time when she was making the accusations, and I was trying to answer and explain why she may have felt or thought that we were keeping her daughter from believing in God, which was completely not true. And I was trying to explain that. And at that point, I was struck in the face. It broke my glasses, and it hurt really, really bad. Then you know, some time passed, and you know, it was you know, after, I believe it was after the conversation about the money. Again, I must have said something that was a trigger or made her upset. But I was shot in the chest. and, on the left side of the chest. And because I was seated, I think, and I'm not a forensics expert or anything, but, I think because of the angle where I was seated, probably helped save my life. And so I was shot, the angle kind of went in my chest, and bounced off a few ribs, 3 ribs were broken, my spleen was damaged. And I remember feeling, it actually, I remember feeling the bullet inside, I don't know anything about bullets, but, I know bullets when they hit, they're made to kind of fracture and kind of do more damage. I could feel that, literally, where it felt like fireworks were going off on the inside of me. And I still have bullet fragments in my back that I could feel. So that was the first shot. And amazingly enough, I didn't, I was still able to sit there. It hurt, like you would not imagine, but I still sat there and I still tried to calm things down and be engaged at that point. And then it was, I think they had already taken True outside, and the dog. And so True had to get her coat and came out, walked across us. She actually wanted to give us, my wife and I, a hug.
Did she get to do that?
No. And the other thing that made Miss Vincent very upset was True referred to us as mommy and daddy. And so that made her more upset when she said that, and she wanted to give us a hug, but they quickly, she ordered one of the men to basically take her and get her outside. And that's what they did, got her coat and brought her outside.
Was that before or after you were shot?
That was before.
One of those men was ordered by the defendant to take True and the dog outside?
Yeah, at 2 different times. I mean, the dog was the first thing, because like I mentioned earlier, the dog was scared. He was a puppy, he was only a few months old, so he was literally next to my right leg as I was sitting there. And I was trying to console the dog, because I was thinking if the dog made any noise or growled or seemed vicious at all or barked, that they would just shoot the dog in front of the girls. And those girls, they love the dog. So I was trying to keep that from happening. So I had my right hand on the dog, trying to console the dog and pet him. And quickly she got nervous about that, the fact, if I would possibly do something with the dog. So, she said, "What are you doing with the dog?" And I tried to explain. And then she said she didn't like that. So then she ordered one of the men to come and get the dog. And I asked, I said, "Can I have the dog?" And there was our laundry room was right next to where I was sitting. So I was like, "Can I just put the dog in the laundry room and close the door?" And she said, "No." So they took the dog and brought the dog outside.
Who shot you?
Who shot him?
Who shot you?
Oh, who shot me? Miss Vincent.
You've told us that True was taken outside before that, and the dog. What about Libby?
So Libby, my daughter, was initially in the living room. And Miss Vincent ordered her short, the timeframe, not sure exactly how long, but it was, not too long after we were sitting down. So, I think, you know, from what Libby told me initially, she was kind of hiding, or she was crouched down by the end of the couch. So Miss Vincent, ordered her into the kitchen, and told her to stand on the other side of her. And so at that point, when she came, she had clear, view, probably standing about 7 feet from us, my wife and I, just on the other side of Miss Vincent, and told Libby to stand there, and not to move. And she stayed there the rest of the night.
So Libby was standing there when you got hit in the head with the butt of a gun.
Yes.
Libby was standing there when you got shot the first time.
Yes.
How close was the defendant to you when she shot you the first time?
So she was, probably about, so I was sitting next, I was sitting, my wife was sitting just to my left, about a foot from me. And then Miss Vincent was probably a foot or two from her. So, I mean, I'd say 3 to 4 feet from me.
Did she say anything to you before or when she was shooting?
Now, the only thing I remember about being shot in the head was she didn't say anything to me, but the last thing I remember right before that happened was my wife, in a calm, but you could tell that there was fear in her voice. She said, "Please, Siobhan, don't do anything you regret." And that just triggered Siobhan. And she got very angry. She said something along the lines, "I'll show you what I'll regret." And then, from what I remember, right after that is when I was shot in the head.
Is that the last thing you heard your wife say?
Yes.
What happened after you got shot in the head?
So I was shot in the right side of my head, right in the forehead. There's a plate, right in my forehead. And as I said, probably the angle, I believe that, I've said this publicly, I believe that God was with me that day. But the angle, it went through my forehead, through my right eye, down to the top, of the inside of my mouth. And I just recently, actually, about a month and a half ago, had 2 surgeries to remove bullet fragments from under my tongue because they were causing so much pain and I couldn't barely eat. So the angle of the gun or the bullet, you know, I think that was part of the reason my life was spared. I remember being aware of the fact that I was shot in the head. I remember the sensation of blood, and I describe it like a river of hot, like fluid flowing from my head. And I fell forward, and I remember the last thing, you know, I was aware of being shot in the head, and I, you know, the first thing I thought was, when you're shot in the head, you die. So I was in my mind thinking that I'm about to die. And I laid down, and the thing I said, "God, help me." And what I was asking for was, God, help me go through whatever transition, death, you know, whatever that looks like. I wasn't afraid of dying, because I believe in God and that I can go to be with him, but I didn't know what that transition was like. So I prayed that prayer and then I passed out. And then at some point, I believe it, somewhere around 15 minutes, somehow I gained consciousness again. And I remember the first thing that I thought was I didn't have that sensation of that blood flowing from my head. So I thought maybe I'm not going to die. And so I sat up and I found some strength there we have a bench right where the shoes are. And so I found some strength to sit up on the bench. And I knew that they had taken our phones. I didn't know if they were still in the house or not. But the first thing I thought was I have to get to the neighbor's house and get help. So I sat there and I was putting my shoes on, and the thing, probably one of the hardest things is as I sat there and I was putting my shoes on, I looked over and saw my wife. And I knew the moment I saw her, she was dead. She was sitting there. She wasn't even laying down. She was sitting there and her head was hanging down, and I just literally saw blood flowing from her chin. That's an image that will stay with me the rest of my life. But I put my shoes on and I opened the garage door and I hesitated and I said, Lord, please don't let them be in the driveway. And I hit the button to open the garage door and walked out the garage. They were already gone. And I walked over to my neighbor's house, and my first neighbor wasn't home, and so I ended up having to walk down the street to our other neighbor's house. And fortunately, they were home, and they were amazing. They brought me in, sat me down, and called 911. And an officer from Northfield Township Police Department was the first one to show up. And he was amazing. All of the officers of both Northfield and the county sheriff's office have been amazing through this. But he took some information about. He was asking my neighbor some questions as well. Obviously, I was sitting there bleeding and hurt, but I was still conscious. I was still able to answer questions. And I remember after him asking my name, like who was in the house and things like that. I remember him saying, he said, okay, and he put his arm on my shoulder to kind of comfort me, and he said, okay, I'm not going to ask you any more questions. And we were still waiting for the ambulance to show up, and I remember saying, that's okay, if there's anything you need, I remember what happened. And he said, do you remember who did this to you? And I said, yes. And I gave him Miss Vincent's name and even spelled it for him. And then the ambulance came and took me to the hospital.
Did you see anyone else in the house before you left? No, just your wife and you described.
Yeah.
Okay. So Livy was not there anymore as far as you could see.
No.
Did the defendant have permission to be in your home that night?
No.
Did the defendant have permission and authority to take True from your home?
No.
Did the defendant have permission and authority to take your daughter, Olivia, from your home?
No.
Oh, yes, I think.
Please.